also notice. Anyway, you go on.
Thank you very much, Honorable Naomomo Latte.
Thank you, Mr. Speaker, Mr. Chairman, for indulging me. I am very much concerned about what is happening here. And in as much as we don't want it to look like newcomers are being gagged, I think that parliamentary practice and procedures transcends the presence of this parliament. If we want to do it, we have to do it right, because you'll be going out there meeting other parliaments. So in the name of supporting first-timers or newcomers, all of us are still learning. But if we refuse to learn the right way, we will go out there and embarrass not just ourselves, but the Parliament of Ghana. So I'll plead with us, in as much as we want everybody to have the freedom to express himself or herself, let us do it within the laws, so that when we go out there, we'll have the confidence to operate. Leadership will not be there all the time to protect us. Even leader might not be on the floor of Parliament every time we have to rise and talk. So if we don't learn it the right way, we are the ones who are going to suffer. So I'll plead with you. Let's do it the right way. Thank you.
Thank you. Thank you very much. We've been patient the whole day. Sometimes you get up and put on the microphone without being given the floor. We've been tolerant. It doesn't happen anywhere that you get up and then you put on the microphone. Somebody is asking a question. Then you said you are on a point of order. How do you take point of order on a question being asked? Well, you said you have one question more. May you proceed to ask the question.
Mr. Chairman, thank you very much. I want to believe that everything is being done from a good place.
Can you proceed with your question? Can you proceed with your question?
Yes, leader, thank you. So, Honorable Nominee, my question is, have you filed your asset declaration?
He's asking whether you have filed for asset declaration.
Yes, I have. I'm always compliant with asset declaration, the filing of asset declaration. I've done that. Not for 2025, but for the last parliament, I filed my asset declaration.
Which is 2020, ending 2024?
Yes.
Okay. But I don't think the committee has a copy or evidence of filing. When I'm looking at the Constitution, if you look at the Constitution, Article 286, yes.
If you have a follow-up, please go ahead with your question. The follow-up.
Before you come in to ask the question, I want us to be guided by the constitutional imperative in Article 78, which states that for you to qualify as a minister, you must qualify to be a member of parliament. The nominee before us has just gone through election and was elected the 4th time as a member of parliament and sworn in as a member of parliament. So let us be guided by the constitutional imperative in Article 78 and 94.
All right, thank you, Mr. Chairman. So, Mr. Nominee, your law firm, that is Ayine, Fairley & Co., is on record to have been used as a registered address for a company called GPGC. Now, my question is, did you advise on the agreement between GPGC and the government of Ghana, of which you were the Deputy Attorney General then, and which led to a judgment debt of $134 million against the state.
Okay. So, Mr. Chairman, it is important to set the record straight because this is a House of Record. This is a Committee of Record. I became Deputy Attorney General, I think, in April 2018. When I was nominated, because I did not have the right to practice, my firm, or the firm of lawyers to which I belonged, was being run by Dr. Abdul Basit Bamba. And when GPGC came into Ghana, he was a lawyer who was approached to help them navigate the process of company registration. And he was the one who registered the company for them. And he had the right to do so to earn a living. He wasn't banned from practicing because I was Deputy Attorney General. Subsequently, Dr. Abdul Basit Bamba left Ayine and Fele, now Ayine and Partners, and when he was leaving, because GPGC was his client, he took them along. Okay? At the time of their PPA, he was no longer a member of my law firm, and I had no dealings whatsoever with GPGC in my private capacity prior to being nominated and appointed Deputy Attorney General of the Republic. And my former boss, the Honorable Marietta Brew, was very gracious to me because I came from academia. And one of the things that, the subjects that I taught, and I'm sure you took my natural resources law course, I was the head of the natural resources law department that included, petroleum. So she, subject to reporting to her, I was in charge of the petroleum and energy aspects, of any transaction that came to the department. Yes, so I issued a legal opinion on GPGC, all right, which was, because the PPAs are standard, the provisions are standard. You can take any normal PPA, the variations are not many. So I issued a legal opinion for them. I signed it for and on behalf of the Attorney General. So technically speaking, it was Honorable Marietta Brew's opinion, not mine. But whatever the case, when the dispute started because of the actions and omissions of your government, I was no longer in office, and I never acted as a private legal practitioner in any of the disputes. Mr. Chairman, that's all I can say for now.
I believe you have exhausted your questions. It is now the turn of
Thank you.
Jerry Ahmed Shaibu.
Mr. Chair, thank you very much. The name is Shaib, S-H-A-I-B, with all due deference. Dr. Ayine, congratulations.
Thank you.
Doc, in 2021, during the hearing of the election petition, you were cited by the Supreme Court of Ghana for scandalizing the court. The matter was referred to the General Legal Counsel. The matter is still pending. My view and my question is that, are you, with all due deference, not in the position to have the matter resolved before you take up this high office of Attorney General and Minister of Justice? Thank you.
Yeah, thank you, Mr. Chairman. Thank you, Mr. Chairman.
Honourable member, before you come in, the matter is pending quasi-judicial decision. I believe we have a lot of members of parliament who have been sworn in with the matter pending judicial decision. To what extent does a member's involvement in a pending lawsuit disqualify him from being a member of parliament, let alone a disciplinary proceedings against a member. So, with all due respect, we need to be fair to all manner of people, and we ask very fair questions to the nominees. So, ask another question with all due respect.
Mr. Chair, thank you very much. I'm not too sure if I can respond to your question before going to the other question.
See, that is why I've indicated that the practice in the House is that you are guided by the chair. You are guided by the speaker. So you take the guidance and proceed accordingly to ask another question.
Very well, Mr. Chair. I take a cue. Dr. Ayine, during the Mills Mahama government, in which you served as the Deputy Attorney General, the state lost a number of international arbitration cases and local ones as well. And to a larger extent, some amounts of monies involved were quite humongous. My question is that how do we prevent the recurrence of such situations? And the case that comes to mind is the Balkan case. Thank you.
Thank you very much for your question. Nominee, your answer, please.
Yeah, Mr. Chairman, there is never a perfect government. And so sometimes public officers act in a manner that incurs liability for the Republic. But as I said, when we were in office, we did very well in trying to prevent such situations. The Balkan situation arose before I took office as Deputy Attorney General. And in fact, by the time I was Deputy Attorney General, the arbitration was at an advanced stage. In fact, I think they were awaiting the award. And the award came down in favor of Balkan. I think it was about $12.5 million or something to that effect. $13 million in favor of Balkan. For us to be able to prevent such situations, state actors, I mean the ministries, departments, and agencies, and the public officers must make sure that they do the right thing. So, for instance, one of the things that I want to emphasize, which we started briefly before we left office, was for us to conduct legal due diligence, of all companies that are seeking to do business with the government, especially where the stakes financially are very high. And so we will attach the legal due diligence report, even if we ourselves cannot do it. We'll get private law firms to conduct the legal due diligence so that we do the right thing by the law. Mr. Chairman, I think we're all in this country when a certain huge transaction came before Parliament, and then when the company was being traced to London, we realized it was a hairdressing salon, CNTC, and it was not President Mills who was in power. It was not His Excellency John Dramani Mahama who was in power. It was His Excellency John Agyekum Kufuor, a man that I respect very much, whose government was in power. It was a hairdressing salon, Mr. Chairman.
Thank you very much. Any follow-up question?
Last one. Thank you, Mr. Chair. Dr. Ayine, so my last question is, what are the kinds of agreements that ought to receive parliamentary approval under Article 1815 of the 1992 Constitution?
I'm surprised my former student is asking me this fundamental question. Where there are loans, loans and, international economic or business transactions in which the government of Ghana is party, or to which the government of Ghana is party. Thank you, Mr. Chairman.
Thank you very much. We now take a question from Honorable Samia Uku.
Mr. Chairman, Thank you for emphasizing that question. Congratulations, nominee. Doc, I want to refer you to an interesting case, a case of a company called Elan International. And I want to believe that you are familiar with the company Elan International. And in laying the foundation, just for a minute before my question, Elan International, sometime in our history, had a case and made a claim subsequently to the international arbitration, where, as we speak, since 2005, they only waited to file these arbitration claims of $320 million against the government and the state of Ghana. I'm also reliably informed, and I stand to be corrected, that sometime 2014, 2015, when you happen to be the Deputy Attorney General, you tried to settle this matter somewhere in India and Dubai. That I stand to be corrected on that. But there was somewhere in 2014, 2015, in your capacity as a Deputy Attorney General. Now that they have filed these claims of $320 million, and being a company that you are familiar with in terms of the history of this case, what assurances can you give the people of Ghana, and for me, my constituents in Akuapem North, that our incoming principal legal advisor to government will be fair in handling this matter so we do not lose revenue? And I'm asking this because, respectfully, if you will just observe, many of the questions hovers around judgment debt. And I'm not taking a partisan position on this matter. And it's because the state, over several decades, we have lost significant revenue through some of these claims, whether under government A or government B. So it's become an industry for some people, an element that some operate across these political parties. And also, lastly, for the record, it's not just Woyome case that preceded you, but also under the same Mills Mahama government, you had Isofoton and the rest as well, just as a matter of record. Thank you.
Thank you very much. May you proceed to answer.
Thank you, Mr. Chairman. I want to put it on record that I have never served as counsel for Elan. Yes, I was involved in two aspects. One was the case, the famous promissory note case that was brought by Standard Bank Offshore Trust against NIB. And then I served as the lawyer for NIB. As the first defendant, Elan was the second defendant, but had a completely separate legal representation. So I've never served as their lawyer, so I'm not conflicted in any way. I also want to put it on record that I am not aware of this arbitration that you have referred to. And Mr. Chairman, I believe we are a committee of parliament, but there are certain rules and practices and conventions of the legal profession that we need to abide by very, very carefully. When a matter is pending before arbitration, you are not even supposed to discuss it. That's what is the position. Even when an award has been granted, especially when it is before bodies like the London Court of International Arbitration, the International, the Permanent Court of Arbitration, etc., you are not supposed, to discuss them. But as Attorney General, I will take all the steps that are necessary, as I said, to protect the interests of the Republic. Because once I'm sworn in, the Republic is my is the only client that I have. And I must act in the best interest of the client in accordance with the ethics of the profession. So I will do everything in my power to ensure that we defend vigorously the interests of the Republic in this arbitration that you are referring to.
Thank you very much for your answer. I will allow you one follow-up question, if any.
Thank you very much, Mr. Chair, and thank you for your generosity this evening. Mr. Chairman, I think it will also be hugely unfair for the Parliament of Ghana to be precluded from discussing a matter because it's also pending before the arbitration, because it has significant bearing on our finances. And as we all know, we are not in normal times as far as revenue is concerned. The matter that I raised was to draw your attention. Once you are not aware that they have filed an arbitration claim of $320 million, I'm only informing you in advance so that, God willing, when you are gifted with that opportunity, it should be one of the issues before you. Because once they have made that claim, it is clear that they are taking steps to extract that from our very dry pocket as well. Thank you.
Is that matter still pending?
Yes. Because in fact, they have filed a claim in November, and that's why I'm informing the incoming Attorney General about it.
Well, be guided of the fact that we cannot be commenting on the matters of judice.
I take you from the chair.
Thank you very much. It's done the last question. No, it was not really a question. You are just seeking the indulgence of the nominee. Is that also?
Exactly.
Then I came in to say that, is that matter pending a judicial decision? We cannot be seen to be commenting on the matter sub judice, and you take a cue from it. Is that not so? So I am most grateful for you taking a cue from it. It's now the turn of Honorable Patrick Yao Buama.
Honorable Adongo, you are here for the finance minister, so you can leave. Why are you questioning the chairman? Thank you very much, Chairman, and the opportunity. Let me use the opportunity to congratulate my lecturer and senior brother and a firm believer of the Mischief School. And I'm sure Professor Kumadu will be very happy to see you in the chair. Congratulations, Doc. Doc, we've been talking about aura, special prosecutor, and what have you. People want to find a very quick way in administering criminal trials in this country. The immediate past Attorney General came to the floor, introduced an amendment to Act 30. It went through first reading, second reading, and consideration stage. But it could not see the light of day because we could not take it through the clause by clause and also the third reading. Would you consider reintroducing the bill to enable your office take the necessary steps in the reforms proposed therein in our criminal justice system? Thank you very much.
Yes, Mr. Chairman, thank you. If the honorable member is seeking to know from me whether in terms of the scope and substantive content of that bill, it will be introduced as it was, my answer is no. The reason I disagree fundamentally with some of its logic. The whole idea that preliminary applications are being used to delay and stymie the conclusion of trials, I disagree with fundamentally. I think that lawyers should be allowed, if there are technical issues that judges have overlooked, they should bring applications, as many applications as they can. It is incumbent upon the judiciary to dispose of those in an expeditious manner so that the substantive trial can proceed. To bring statute, to basically try to constrain lawyers, from filing preliminary applications. Some of them are, fundamental in terms of seeking to do right by the law and procedure under Act 29 and Act 30. So I disagree fundamentally with it. I will take a critical look at it. I took part in the consideration, but I had fundamental issues with it. I'll take a look at it and see if it should be ever tabled at all, or that the status quo ante remains.
Thank you very much. Your submission is in tandem with the views of the Constitutional Legal Committee at the material moment. Why should we be in a hurry to convict people? I think anybody accused should be given all the opportunities to defend himself.
Yeah, Chairman, you and Honorable Ayine were very key on this bill. Let me go ahead and ask my question. I'm very satisfied with his answer. Honorable nominee, your office, your former office, and I believe, God willing, this House will approve your nomination to be AG, used the staff and the resources available at the AG's department to fight some arbitration cases. They did not hire any external or foreign counsel to assist their office, and they were successful in most of the cases. I'm sure you're aware of it. The ADR Center has been activated and set up in accordance with law, for which I believe that the forum for some of these arbitration proceedings ought to be Ghana, to save cost and to use the capacity. You are going to occupy the biggest chamber in the country. Are you going to assure the country that you will not expend so much money in the hiring of foreign counsel and you situate arbitration within the confines of the country so that lawyers and practitioners and the big staff that you have at the AG's department will have access to the ADR Center and practice their profession? Thank you.
I will otherwise term your question, the bar must prosper. Honorable nominee, you may proceed to answer the question.
Okay. Thank you very much. The use of in-house expertise is not new, but sometimes it may be the case that certain matters are specialized areas. There's no in-house expertise, to handle them. And sometimes they are also complex, and if the jurisdiction is not Ghana, and you're not familiar with the law and practice of the seat of the arbitration, you have to be careful that you have to be careful in not disregarding any advice to bring in lawyers from that jurisdiction in order to be able to conduct the case very well. So yes, I will consider the use of in-house expertise, but it's not exactly true that they use in-house lawyers throughout. The Attorney General kept saying that, but during the transition, we had evidence that they consistently paid foreign lawyers millions of dollars to do cases for this republic.
Honorable Boma, you have a chance to answer.
It's a very important question, and I want to elicit the views of my respected senior on the jurisdiction of the Supreme Court. Very wide. I ask this question every year, and I want to hear from my senior. You know the jurisdiction of the Supreme Court is very wide. From appellate, you know everything. I need not go over it. Do you think the current composition of the Supreme Court ought to be augmented with some new appointments? And what do you think must be the ceiling, given the fact that some people don't even understand the workings of the courts? And do you think they have the capacity, as we sit here now, to adjudicate on all the matters pending before them, from chieftaincy to appellate to whatever. A lot of them, about 7 of the jurisdiction.
Honorable Boama, if you said some people, who are those people?
Not every person understands that the Supreme Court handles a lot of matters, apart from what they perceive to be only political or constitutional matters. Some may be appellate matters. They have jurisdiction over chieftaincy matters originating from the House of Chiefs or the judicial councils, judicial review matters, and what have you, invoking the original jurisdiction of the court under Article 130. A lot more, about 7 or so. Election petition. And you have only 11 people handling all these matters. That's why I'm asking him. That's the gravamen of my question.
Very, very well. Yes, Honorable Nominee.
Yeah. Thank you very much. Mr. Chairman, I agree with the Honorable Member that the jurisdiction of the Supreme Court is very wide, and he has already enumerated them, so I don't need to repeat them. But you can deal with the issue of the caseload in 2 ways, in 2 broad ways. One is dealing with them through the adoption of very efficient mechanisms of deciding cases. All right, so I'll give you an example. In the United States Supreme Court, which has only 9 members, okay, and they have operated with 9 members for over hundreds of years. The United States of America is bigger than this country. Cases come from the district court all the way through the various circuits, okay, and their circuit courts like, the 9th circuit, the 6th circuit, and so on, are very big. And sometimes, if there's a federal element in a state matter, it can emanate from a state Supreme Court to the United States Supreme Court. And yet they still have only 9. You know how they deal with the cases efficiently? The judges, for every case that is coming, they look at the brief, and if they have already decided the matter, they simply let the registrar write a brief note, and it says set denied. All right? Set denied means that the justices are not interested in looking at this matter. And it's a very well-known procedure. So if you are a practitioner before the United States Supreme Court, you have to be very, very good at distinguishing cases to be able to convince them, to take up, your matter. So if it comes to them and they let their research, what they call them the clerks will review, they'll go to conference, and then they tell the registrar, right, set denied. That is it. You're not going to waste the time of the court by coming to appear before the court and call, for the case to be called and so on. I think that we should adopt very efficient, procedures like that. Because sometimes people take very frivolous cases, frivolous appeals to the Supreme Court, for instance. I remember once I was before the court, and then somebody brought an appeal that had to do with the fact that he, the lawyer, was not there when a decision was granted against him. So he took this appeal all the way from the High Court to the Court of Appeal and then to the Supreme Court. And the Supreme Court was empaneled to hear him. It was so frivolous. So they gave it to him by way of speaking. They gave it to him that morning in front of all of us. So we should have procedural mechanisms that will sieve out all the frivolous appeals so that the justices are not burdened. One way is also to increase the numbers. But then the court itself, through the the exercise of the administrative powers of the CJ, should divide itself into specialized divisions all right? So you can have the Supreme Court Constitutional Division, and you have 5 justices very specialized in constitutional law who will quickly deal with these matters, okay? And so on and so forth. Of course, you have some of them who are experts in criminal law, like my former teacher, Justice Henrietta Mensah-Bonsu. She could lead a panel of justices who will be dealing with criminal appeals. You know, so specialization may make the court more efficient, and then the burden on the court will be reduced. But that would mean, for instance, that instead of 11, we may have 15, so that 5 each, you know, could deal with, because the court is properly constituted with the Chief Justice and 4 other justices, you know, of the court. That is what I would say for now.
Thank you,
Thank you
Dr.
very
Ayine,
much.
and congratulations. I wish you the very best.
It's now the turn of Honorable Deputy Minority Leader.
Thank you very much, Mr. Chair. I would like to congratulate the nominee. It's a very good associate of mine. We've been to several programs together, and I've listened to him, to his lectures, and I must say that I don't even have the locus to be asking any question, but something is very dear to my heart, and which I must pursue. I remember in the previous Mills Mahama NDC administration, in which you served as a Deputy Attorney General, the state lost a number of international arbitrations and local cases at huge cost of the state. An example is the Balkan arbitration, in which about 13.5 million was awarded against the state. My only question is, how are you going to avoid the occurrences of these situations? Thank you.
Honorable nominee.
Yeah, thank you very much. Mr. Chairman, I have previously answered this question, but I think I would indulge and then say maybe as closely as possible to the answer that I gave, which is that, you know, we will do our best in the department to ensure that we negotiate well as far as the agreements are concerned. We do not take steps to abrogate when we know that the state will incur liability. We make sure that public officers, you know, who are involved in these transactions do right by the law. So when we act right, we will win at the arbitration. It is the arbitrary termination or wrongful terminations, sometimes because the public officer that is engaged, you know, in that conduct, that is a public officer issuing the letter of termination, does not, or is not mindful of the financial liability that will accrue to the Republic as a result of his or her conduct. I think that we should begin to also punish, you know, such people when they, you know, misconduct themselves. That is all that I'll say for now. So when they know the legal consequences will be adverse, they will be careful not to arbitrarily terminate and then bring about judgment debt.
Thank you very much. Any further questions?
Yes, thank you very much. What would you do in your capacity as a Attorney General to continue the tradition of a zealous defense of the state's interest in international arbitrations? What specifically will you do? Yeah.
Thank you. Any answer to the question?
We definitely will be putting our best foot forward by getting lawyers, either local or international, that are knowledgeable, that are skillful, and that have integrity to represent the Republic and defend its interests before these arbitral tribunals.
Thank you very much. Thank you. It's now the turn of the minority.
Professor Ayine, congratulations. Your academic credentials and prowess is well known, but I know you as a man of fashion. And I've always admired you for that. And I'm sure that as Attorney General, I don't know whether your fashion will change, but congratulations. But I have one important question for you. Ghana ranks 72 out of 180 countries in the 2023 Corruption Perception Index, indicating persistent challenges with the issue of corruption. What innovative measures will you champion to strengthen the capacity of anti-corruption institutions in the country?
Thank you for your question. Any answer?
Thank you very much, Honorable Chairman. Just to let the nominee know that my fashion taste will not change as Attorney General. The Honorable Member, I'm so tired. I'm reversing the cut. Yes. When it comes to the issue of corruption, as a country, we've tried various mechanisms. We've tried various institutional measures. We formed commissions of inquiry. If you go back to our history, the Olenu Commission of Inquiry was into the sale of import licenses and the bribery associated, therewith at the Ministry of Trade. For the lawyers around the table, you remember the case of Kenya versus the Republic. That case, arose out of the Olenu Commission of Inquiry report. So using commissions of inquiry have been, has been one of the things that we've used to fight corruption. Of course, constitutionally, you remember that SRAJ is also another institution that has an anti-corruption mandate. And at the beginning of the Fourth Republic, you remember very, very well the work that its first chairman, Emil Short, did with, high public officials appearing before the SRAJ. Some of it went to the Supreme Court in challenges, and there are decided cases dealing with the procedures that were adopted and so on. We've had, various other bodies that we've used and institutional measures that we've used to fight corruption. So, Mr. Chairman, there is no shortage of institutional measures, all right? When you set up institutions or you create institutions, and by the way, institutions are the rules in the society. So, the norms, the practices, the hardcore statutes and so on are all, institutions. So there's no shortage of institutions in this country. But sometimes implementing the measures is where the problem is. So I'm going to give you one example. So we have the Whistleblowers Act, right? The Whistleblowers Act is supposed to, give whistleblowers who may be near the action as far as corruption, bribery and corruption is concerned, to provide the requisite information to law enforcement agencies to take action, okay? And when I was Deputy Attorney General, we had situations where a whistleblower, gave us information, and then we did the investigation, and eventually we recovered over $30 million Ghana cedis. That is the record that is not being talked about. We recovered over 30 million Ghana cedis, which was which was paid by those who were involved. But because of confidentiality reasons, I cannot mention those who was involved. So, for instance, the plan which I have discussed informally with His Excellency is for us to have the whistleblower agency in every district. And then to publicize the procedures, create a hotline where if there is wrongdoing that is happening, okay, we will, that hotline can it can be the regional chief, the chief state attorney, being called and, a report being made so that he can then, with the police and the other investigative bodies, investigate and then, ensure that the wrongdoing which is being reported, the evidence of it is gathered and so on. So in every district, we'll implement it and then have a hotline that can be used to report, information about corruption. So the anti-corruption institutions, okay, should not be thin on the ground or centered in Accra and, depriving ordinary people of the opportunity to report, acts of corruption. Well, of course, under the Whistleblowers Act, when you report and there's a recovery, you are entitled to 10%, a percentage. And I remember that in this case that I've cited, the whistleblower was actually paid. The Honorable Atachia, eventually, if you want to, cross-check what I'm saying, you can ask him. The Honorable Atachia represented the whistleblower in his pursuit of the 10%. We agreed to pay when MPP took over. There was some hanky-panky, and then the whistleblower had to go to court. So that is an incentive, for whistleblowers to report. So, Mr. Chairman, we need to operationalize and make sure that the anti-corruption institutions, the anti-corruption measures permeate all the way to the local level. That, during the revolution, of course, there were excesses, but during the revolution, the Honorable Cletus Avoka is here. Those days when we were young men in Bolga, they were the revolutionary lawyers. And of course, the reports, they caught many people, civil servants,